Good afternoon. This is Andrew Bluestein, Garfunkel Weil. I want to thank everyone for joining us this afternoon. I will not be your guest speaker. That will be Sal Puccio. Before we started, I wanted to just make two introductory comments. The first one is that if you're on this call, it's because you're on our ASC symposium mailing list or you were referred to it. It would be a great thing to register for the 4th annual New York Metro ASC Symposium. The agenda has been published. You can go to the website, which is www.newyorkmetroasc.com, and it's on your second slide. The agenda is jam-packed with good things, and hopefully we will see you there in October. Also, the second thing is if there are topics that you want to hear about between now and then that relate to ASCs, feel free to give Sal or myself an email, or you could send it to info@NewYorkMetroASC, which is also on slide 2. We are trying to create a community of learning, and what you want to find out about is something that we want to help you with. Okay, and with that, I am going to turn it over to Sal to talk about overtime claims, a threat to ASCs.
Good afternoon. Thank you, Andrew, and thank you to all of us joining us today for this webinar. We expect a few people to continue to join us, and we hope they do so. Today's topic is overtime claims, a threat to ASCs. As Andrew had indicated, our purpose is to provide information to our clients to help them understand new developments as well as old precedents in particular areas of the law. I'm a partner in the healthcare litigation group, and for the past several years I've been working extensively with clients, particularly employers, dealing with overtime claims. And Andrew and I put together an agenda that we've been working on with a number of our clients in a number of different industries, and we thought it would be of particular relevance for the ASCs, given the trends that we're seeing. So today what we're going to do, we'll speak briefly about Garfunkel Weil, for those of you who are not familiar with our firm. We'll give a brief introduction to overtime and related claims. We'll talk about the trends we're seeing in wage and hour lawsuits, and in particular, the targets of plaintiffs' attorneys. Then we'll delve into a little bit of the specific legal issues, the challenges facing ASCs, and how to best prevent or defend against an overtime or the related claims. If time permits, at the end, we will have a brief question and answer period. What I would suggest is if you do have any questions, but you're concerned they might not get answered, please submit them through the webinar portal or at the email address that was on the earlier slide, and we will certainly do our best to respond to the emails as soon as possible after the webinar. I do understand that we're at the 12 o'clock hour, which is lunchtime for many of us, so as not to keep anyone from getting their lunch meal in, which will be a topic of discussion today. We will break after about 35 to 45 minutes, but we will again work to submit any answers to the questions that you may have. Garfunkel Weil was founded over 37 years ago with a single purpose in mind. And those of you that know the firm and know Andrew know quite well that we service our healthcare industry clients like no other in the area. We now have offices in 4 locations. We have 2 New York offices here in Great Neck, where I'm located, and Andrew, as well as our Albany office. Now, as a note, you'll see we've recently acquired and hired 3 partners who are former general and senior counsel for the Department of Health. They're working out of our Albany office. We also maintain offices in New Jersey and Connecticut. Given this spectrum of where we represent clients, the focus of today's ASC will be basically federal law as well as the implications in New York, New Jersey, and Connecticut. Garfunkel Weil is consistently ranked a Tier 1 in healthcare by the Chambers USA. We counsel and represent more than 60 hospitals and healthcare systems, as well as individual practitioners, organizations, or medical practices. With that in mind, we're going to speak about overtime and related legal requirements today. Now, the first question when Andrew and I came up with this topic and we're thinking about it was, well, why is this important? Shouldn't clients already be familiar with this, and aren't the programs already in place within our clients' offices? And for the most part, they are. But what becomes very tricky here is laws constantly are changing, regulations are being updated, and lawsuits continue to expand the coverage that we see that applies to employers. This brings me back to about a year ago. I was having a discussion in court with another attorney, and I was working on another case while I was waiting in court, and the attorney asked me about it. It was a wage and hour case. And some of the questions that the attorney had for me were surprising. He was asking me, well, do I have to pay my associates overtime? Do I have to pay my receptionist overtime? Do I have to give medical leave to my associate that's going to be going out on maternity leave? And I started to realize that a number of people just don't realize the complexity of what's been happening and changing in the overtime laws. So let's talk about what overtime is for just a moment. We're going to focus primarily on the FLSA, which is the Fair Labor Standards Act. Federal overtime provisions are contained in the Federal Fair Labor Standards Act. What they require is that unless exempt, employees covered by the FLSA must receive overtime pay for hours worked over 40 in a work week at a rate not less than time and 1/2 their regular rates of pay. We'll talk later about specific exempt employees. I'm sure many of you are familiar with the exemptions, in particular our doctors, our executives, and certain administrative personnel. States, including New York, New Jersey, and Connecticut, also have corresponding overtime laws. Typically, what we see is that those individual state laws expand upon the Fair Labor Standards Act, meaning that they make it more restrictive and more cumbersome on employers. They're more protective of the employees. The basic way to view it is the FLSA is the bare minimum that you're going to have to meet. It's the state laws that you'll have to pay particular attention to with respect to all of the requirements, such as additional minimum wage requirements, record-keeping requirements, statute of limitations, and the impact upon class action and collective actions. Now, I recognize that the concept of overtime, paying an employee time and a half when they work more than 40 hours in a work week, can seem basic. The issues that we see fall under misclassification of those employees you deem to be exempt. One common misclassification we see is with registered nurses, and we'll discuss that later on. And of course, that's of particular importance to the ASCs. Additional errors or reasons for errors in payroll are change in laws, simple errors in a payroll calculation or policy, and lately what it's been is over-aggressive plaintiffs and plaintiffs' employees. Excuse me, and plaintiffs' attorneys. So what are hourly employees? Hourly employees are those that you pay on an hourly basis. They would be entitled to overtime at 1.5 times their regular rate of pay. There's no limit on the number of hours that an individual can work. Now, employers can set overtime policies that restrict individuals from working overtime without permission. However, as a cautionary note, even if you have such a policy, you cannot prevent an employee from receiving pay for hours they actually work. So please keep that in mind, and we'll touch on that a little bit later. Typically, employers can set up a 40-hour work week schedule. That schedule is set by the employer. So it can be Monday through Sunday, Sunday through Saturday. You have the option of choosing and setting that up, but that needs to remain consistent. It's not something that's fluent and can change from week to week so that you can maximize the hours worked and minimize the overtime worked. As a basic example of what we're talking about in terms of our numbers, an hourly employee that you're paying hypothetically $10 an hour. based on that hourly rate of $10, the overtime rate for that individual is $15 for an hour. So if that employee works 50 hours in a week, the amount due is presented here on the slide at the calculation below. 40 hours are paid at the $10 rate. That's their hourly rate. The additional 10 hours are paid at $15 for a total of $550 per week. That would be the employee's rate of pay. There are only specific limited circumstances when an employer can actually agree upon a different rate for overtime. Those circumstances would be if an individual is working in two separate and distinct roles for you. If he serves as one role making $10 an hour and he serves in a different role making $8 an hour, for example, you can then agree upon an overtime rate. It's far and few in between, and we won't spend much time talking about it today. I raise it only because we've received a number of questions regarding that difference from clients in the last few months. And if you do have any questions, please feel free to reach out to me either by phone call or email, and we can walk you through that. Now, I have bolded here the fourth bullet point. It says pay attention to lunch breaks, pre- and post-shift work, and request to stay late for specific cases or come in early for meetings. And the reason I've highlighted that for you is because that's where we're seeing the biggest trend in what's causing the shift towards these overtime lawsuits. What you want to focus on is, are there potential policies that you have in place already, including automatic meal deduction policies that would automatically pull out an employee's 30-minute lunch break? Well, what happens if there's an emergency and a procedure is going on in your facility that causes the nurses or the staff to work through lunch? If that automatic meal deduction policy doesn't account for that or doesn't provide some system or change, the employee is docked for the lunch break, the 30 minutes, although they work through lunch. That becomes an issue. That's been one of the biggest targets for plaintiffs and plaintiffs' attorneys against healthcare facilities. We've seen tremendous litigation against hospitals, healthcare facilities, ASCs, home health aides, all which involve automatic meal deductions for lunch periods. In addition, the pre and post shift, that's pretty self-explanatory, but what employers don't typically realize is sometimes a nurse will come in 15 minutes to a half hour early so they can learn the file and see who's on the floor, who's up for a procedure, or they'll stay 15 to 30 minutes late after their shift to complete paperwork to do the necessary handoff and transition to the incoming nurse for that time period. That's all recordable time and must be compensated. Some employers were using a set schedule. Sally worked 9 to 4. Jim worked 4 to 11, or overlapping, and just paying on that set schedule. You have to be flexible. There has to be room for deviation with respect to individuals who are coming in early a little bit or staying late. So again, I highlight that, and we'll spend a little bit more talking about it later in terms of how we can best prevent against that. Pay stubs also must show the different rates of pay for the individuals. In a moment, we'll talk about specific record-keeping obligations, but I bring it up here because it's important that you know when paying an employee, the pay stub that they receive must show, as we've talked about here in the slide, in the example above in the third bullet point, you received $10 an hour for the 40 hours you worked. There must be a separate line item showing you received $15 for the 10 hours of overtime you worked and the total amount of pay. Also included in that pay stub would be any deductions that the individual may have, as well as any vacation, sick time, any other additional amounts of money the employee is entitled to receive. So you have to have all of that information broken down. Lately, I've been seeing too many instances where employers are turning over their payroll to these larger payroll companies. And the payroll company is simply listing on the check 50 hours, $550. That's incorrect. That's a technical violation of the record-keeping obligations and the wage statement obligations under New York, New Jersey, and Connecticut law specifically. There are consequences for that. The consequences include minimum fines as well as attorney's fees. So again, I highlight that and caution that because we're defending presently several lawsuits where there's no overtime violation, but there might be an issue or error with respect to the wage statement that the individual received because it technically had incorrect information. So again, I want to caution you about that and make sure we're prepared to deal with that. And if you have any questions, we work with a number of payroll vendors, payroll companies that we can recommend, as well as reviewing your records to make sure they're in compliance with those particular laws. As a last point on this page, because it's a question I receive a lot with respect to this issue, well, what happens if I have an employee who I pay a salary, but it turns out they're actually entitled to overtime pay? How would I then know what to even pay them or go back and figure it out and fix it? Well, the short answer is what courts will do and what the Department of Labor, who enforces the FLSA, what they'll do is they'll take that salaried amount for a given week, they'll divide it by the total number of hours that were worked that week, and then that will be the fixed hourly rate that you paid them. So in essence, what happens is you really increase the individual's hourly rate significantly, and it winds up costing employers a significant amount of more money because now time and a half is based on that higher number. Next slide we have talks about applicable time periods for violations. And this is relevant because with the assessment of damages that will be discussed later on in the presentation, the fines and fees can be significant. So under the FLSA, it's a standard 2-year statute of limitations, meaning if there's an error or problem in payroll or mistake that you made, an employee who brings a claim under the FLSA can go back 2 years. Now, if the error is deemed to be quote-unquote willful, the FLSA allows the individual employee or former employee, as it may be, to go back 3 years. They get that added year. Under New York labor law, it's 6 years. New Jersey's independent laws is 6 years, and Connecticut has 2 years. With respect to the willfulness under the FLSA, almost every violation that we see is deemed willful. The only way you can avoid it is if you say, well, I relied on this particular department or agency's opinion, or the Department of Labor came in and did an audit and we developed a system and process to use to pay our employees and we were following it and we made a mistake based on that. Other than those limited exceptions, everything is really going to be deemed willful based upon all case law that's out there as well as agency and department interpretations. As you can imagine, when you're talking about the 6 years under the New York and New Jersey labor laws in particular, that's a significant amount of time that an employee can look back to gain their alleged unpaid wages. And record keeping. I had alluded earlier to certain record keeping obligations. So in addition to that basic overtime requirement, paying 40 hours, paying time and a half for over 40 hours, there are also obligations with respect to what records you must maintain. Now, this is important on a practical level for a minimum of 2 reasons. One, compliance. As you'll see here, we state the standard that each employer shall preserve for at least 3 years payroll records, collective bargaining agreements, sales and purchase records. Records on which wage computations are based, including your time cards, piecework tickets, wait rate tables, work schedules, etc. They must be maintained for 2 years. So from a compliance standpoint, you need to meet that bare minimum to have the records so you can show the department or the employee. From a more practical level, though, you are going to absolutely need these records and depend upon these records if you're ever faced with a challenge to your payroll policies. Whether it's an individual who sues you and says, I didn't get my overtime, or it's a Department of Labor who, again, enforces these regulations and comes out and says, well, we're looking to investigate you and perform an audit of your payroll policies. You will absolutely need these records to show them and say, here's our payroll policy, here are our records, here are our documents, and they should hopefully speak for themselves. In defending these lawsuits and in also defending investigations or assisting in participation of audits, we allow the records to really chart the course for the defense. If you do not have good records, it makes things a lot more difficult, and you're going to have to make a lot more concessions to either the individual in a settlement or the department. If, however, you have good records, it makes it all that much easier for us to defend you. Presently, I have cases all across the spectrum with respect to records, and I can honestly say, depending upon the records that the client, you, the employer, have, really dictates how I handle the case. In many of the cases, we don't have any records at all, or we have very poor records. That becomes problematic. We're looking to settle and resolve the case as quickly as possible. Other cases where I have good record keeping, I have good documents and wage statements in hand, we put up a great defense. We get in front of a court early and often, and we're all too happy to fight on the specifics of the case. So in addition to those, the regulations we're talking about there with respect to record keeping was specific to the FLSA. State law also has their additional record keeping obligations. I've mentioned some of the statutes there for compliance purposes. There are two components I'll speak to about that briefly. One are the potential damages that you could face, particularly under New York laws, the New York Wage Prevention Act, New York Wage Theft Prevention Act. There are statutory fines associated with the record-keeping obligations that apply to both your records as well as to wage statements. And those would also include attorney's fees. And the second point is just maintaining those records in order to, again, defend yourself. So I really can't stress that enough, that you need the records on hand. One of the reasons I'm really highlighting the record keeping here and going on about it is because, for example, I'm in a present lawsuit right now where we're defending a healthcare provider. They have very good defenses to the claims. There are some questions, however, with respect to some of the record keeping. In some instances, there were overpayments to the employee because of vacation time that was not calculated appropriately or removed, or they were providing too much vacation time. And there are other instances where, because of that same kind of error or issue, an individual might not have received the proper overtime. The main focus now of the dispute before the judge is whether or not there was a breach of the wage statement requirements under the New York Wage Theft Prevention Act. And they're looking at those damages are going to be much more than any damage of an alleged unpaid overtime claim. The unpaid overtime is minimum. We're talking $100 in most cases. But the wage theft prevention damages are $250 per incident, up to $2,500 per individual, plus attorney's fees. So by this point, we're all asking ourselves, okay, well, why is overtime awareness a growing concern for ASCs, or for that matter, anyone in the healthcare industry? Well, let's talk about the trends in these lawsuits and investigations and how they come about and what you can do to start protecting yourselves going forward. I've listed here some federal figures that we have from federal courts and judges. I was recently part of a panel and discussion group with two federal judges talking about lawsuits, wage and hour lawsuits that have been filed on their dockets. And as you can see here from some of the numbers, and we highlight these because it's staggering, and it is supposed to get your attention and make you think twice about your payroll policies. So litigants filed a total of 8,954 FLSA cases between January 1, 2015 and December 31, 2015. For comparison purposes, the prior year, in 2014, there was only 8,086 cases. So we've gone up about 900 or so cases in that time period. That's an increase going back to 2011 of 30%. Again, for comparison purposes, we see only 4,000 FLSA cases filed back in 2005. So we can see we're nearing the doubling mark just within a 5-year period, a 10-year period here, dealing with these specific cases. Federal judges estimate that their dockets are trending with an increase in FLSA and related cases by 10 to 15% over the last 10 years. I had one particular judge tell me that her docket of cases related to employment claims, and wage and hour claims typically fall into that heading, about 15% of the judge's entire docket related to those type of federal lawsuits, employment discrimination, sexual harassment, and wage and hour. And the remainder was criminal cases they handled, breach of contract cases, and personal injury cases and the like. Within the last 2 years, that particular judge has said her docket has gone from the 15% that about just 10% of the entire docket is wage and hour litigations, plus all the other litigations that are out there relating to employment cases. So it's become a very, very trendy type area for plaintiffs and plaintiffs' attorneys. Let's talk for a minute about how do these lawsuits come up. And the reason I bring this up is because in a prior lifetime, but before having the pleasure of working here at Garfunkel Wild, I was on the other side of these claims, and I was working with plaintiffs' lawyers and was a plaintiff's lawyer dealing with employment claims. And we recognized, and this is over a decade ago, about 12 or 13 years ago, we recognized in that area that employers weren't completely complying with their obligations and were making mistakes in payroll. And how do we find that out? Well, typically what happens is you, the employer, let go one of your employees. In your mind, the employee is not doing a good job. They're failing to perform their duties as a nurse, as a biller and coder, or as a receptionist. They're slacking off. You've given them multiple disciplinary notices, yet they fail to meet the requirements that you have for them in your particular facility. So you terminate them. You let them go. Well, I've yet to see an employee who was terminated and accepted the responsibility that they simply weren't a good employee. I'm sure you guys hear it all the time. The employee always has a problem, and the problem is I was discriminated against because of my race, my national origin, my sex, my sexual orientation, or my disability. And unable to take responsibility for their own actions that may have caused the termination, they go to an attorney, and they talk to the attorney and say, I was discriminated against because of my race, my national origin, or I was sexually harassed. Well, the attorney does an intake, and they sit there and go over the intake with the individual, and they quickly see that, well, this is a he said, she said. There's really not much there. You were told you had problems. Let me see your payroll records. Let me see your pay stubs. How were you paid? What time did you show up to work? What time did you go home? And those are the type of questions that plaintiffs' attorneys are asking these individuals that come forward. And quickly they realize we may have a wage and hour claim. We may have a FLSA claim or a New York labor law claim or New Jersey claim. And they prefer to file that way because they get attorney's fees under the particular statutes that protect employees. So I caution you on that and mention that because if and when you decide to start letting go of employees for whatever reason, take it seriously. Consider exit interviews. Consider contacting your attorneys. Contact Garfunkel Wild. We have a great employment group. We deal with counseling of day-to-day issues all of the time. We have dedicated attorneys that deal with that, and we can help push you or place you in the right direction in order to try to minimize the employee from going to complain about some discrimination or sexual harassment that simply didn't exist. In addition to the lawsuits, we have investigations, and I'll cover this just quickly. The U.S. Department of Labor, I mentioned, will conduct investigations. Sometimes these pop up out of nowhere. The DOL will just come in and want to perform an audit of you. Sometimes they come up as part of other investigations. Sometimes they come up as part of an employee running to the Department of Labor complaining against you because, again, you fired them. So we have to be aware of these investigations that take place, and again, that's something that we as your attorneys in Garfunkel Wild can handle and can look into and try to resolve the best way possible for you. Why the increase in FLSA lawsuits or New York labor lawsuits? Well, again, we've touched on this in detail, but I'll just cover it again briefly. Employers find it very difficult to stay up to date on the current and ever-evolving wage and hour laws. As an example, New York passed the Wage Theft Prevention Act recently. We had increases in minimum wage, increases in record-keeping obligations, wage statement obligations, notices that must be provided to employees, and plaintiffs, and more specifically, their attorneys are aware of these laws, but the employers are not. And the plaintiffs' attorneys are taking advantage of this. Additionally, the FLSA, as well as its counterparts in state law, provide for and allow for class and collective litigations. That allows to cover for more claims. So what happens is one individual believes they have an overtime claim. They bring a lawsuit on behalf of themselves and other employees who they believe are in a similar circumstance. And the standard at which a class or collective group, meaning more than just one individual, can be presented to the court is extremely low. So what that means is notices go out all the time to employees and former employees of a potential or alleged overtime discrepancy. That happens, unfortunately. I don't agree with it. I don't think it's right, but that happens, and those notices go out before there's any proof or before the plaintiff has to actually prove that there was an overtime violation. So this sweeps in a number of individuals, and you have more claims to defend. And last but not least, plaintiff's attorneys receive their attorney's fees from you. They receive it from the employer if they're successful. Even the smallest infraction, you miss an overtime hour, you misclassify one person out of a group of 40, one infraction could lead to attorney's fees that you have to pay to the other side. Now, of course, that doesn't factor in the attorney's fees you're going to have to pay to defend yourself as well. We see that different firms, different plaintiff's attorneys firms handle these cases differently. Some are very easy to deal with. They are out there to enforce the rules and want to make sure you're meeting your end of the bargain. However, unfortunately, there are some groups out there that are just honestly looking to make a buck for themselves. So you have to be careful. Targets for plaintiff's attorneys. This goes specifically to the areas of healthcare law that we want to talk about where we're seeing groups being targeted for alleged overtime violations. There's always the hospitality industry that's out there. That's your restaurants, bars, nightclubs, hotels, etc. That's low-hanging fruit. That there's always some kind of issue or problem. We represent several clients in those industries, and we deal with them accordingly. In addition, though, within the last 5 or 6 years, there was a flood of litigations nationwide against hospitals, home health care aides and nursing homes, ASCs to a lesser extent, but that's trending up as ASCs themselves continue to grow, specific to nurses, billers, and coders, and then they sweep in your receptionist and office staff. I've cited a couple of cases here in the third bullet point. Garfunkel Wild was involved in these cases. We defended some of the defendant hospitals in the litigations. The litigations went all the way up to the highest federal court level that they could go. And I'm happy and proud to report that our team here at GW was part of a successful group to represent these hospital defendants, and we had the lawsuits dismissed. Now, it wasn't at great cost and expense to the clients, and there were still some issues that were left out there. Some hospitals were not as lucky. Lawsuits proceeded against them. But nevertheless, we had to deal with the claims, and we saw how the plaintiff's attorneys were starting trying to make these claims stick. And again, as I said earlier, the biggest areas that they were focusing on were unpaid meal breaks. There was an automatic meal deduction policy. The nurses and staff came in 15 to 30 minutes early and stayed 15 to 30 minutes early and left. And the third one was predetermined work schedules. What the plaintiffs were claiming, what the employees and former employees were claiming is that I had a set schedule. I worked 4 days a week for 12 hours. This was my schedule. 3 days a week I worked these 12 hours, but I wasn't compensated for any hours over that. So I stayed early, came in late. There were emergencies that kept me there. There were shift changes where a nurse, for example, failed to show up and I had to do a double, and they never paid me for that double shift because I had a set schedule. And those were the claims that we had to defend against. Now, we're not always as lucky. Some of those cases are now starting to go forward. Damages. Let's say you are faced with an overtime lawsuit and you have to deal with the issue of damages. And what is that going to mean? Well, there are actual damages. Of course, you're going to have to pay the unpaid hours. Any hours that you did not pay, you'll have to make the employee whole for. So in that example we gave earlier on one of the first slides, let's say you paid straight time for 50 hours, meaning you paid $10 an hour across the board for all 50 hours. You're going to have to make up the difference of the time and a half for those 10 hours that you didn't pay. So that's the first piece of it. Sometimes we see individuals that are only paid at 40 hours or 45 hours, for example, but they work 50 and those other 5 or 10 hours are not paid at all. That's less common, but it does happen, but you'd have to pay that unpaid portion. Now, the next line here, the second bullet point, this is the kicker, liquidated damages. Liquidated damages in its simplest form are double your actual damages. It's a penalty. It's per statute. Both the FLSA has it and your local state laws require it as well. So not only are you paying that back time, that $50 that you didn't pay, you're going to pay another $50 on top of that as a penalty. That's going to add up significantly going back 3 years under the federal or 6 years under the state claims. In addition, you're also responsible for attorney's fees. Plaintiffs can recover their attorney's fees. When you're talking about a collective or class action, meaning if you have 15 or 20 employees, you have 40 or 50 employees, hospitals have hundreds of employees, the attorney's fees associated with prosecuting that class or collective action is significant. We're seeing them in the hundreds of thousands of dollars range. Again, that's in addition to whatever fees you might have to pay to your own attorney to defend you. And lastly, there is personal liability to owners or managers who have control over scheduling and can be personally liable. Class and collective actions, just have a brief moment here regarding these because we see some questions related to that. Under federal law, you have a collective action. What that means is individuals have to affirmatively opt in to join the lawsuit. The issue is notices go out to your employees and former employees. It's like those class action notices that you get in the mail for some product you bought from Duracell 10 years ago that's now an issue, and you can join the lawsuit if you like. Those notices go out, but it has your name on it. It has your company's name on it and information about your company and an alleged overtime violation. Again, all before you've even been found to have done anything wrong. Those notices go out, individuals get them, and they have an opportunity to opt in. On your state level, there are class actions. So the same notices go out. People are considered part of the class unless they opt out and decide to sue you individually. So this makes for bigger claims, bigger attorney's fees, potential bigger damages, and for the employer, potential bigger problems. Typically, attorneys will bring lawsuits alleging both federal and state claims, so they have the most flexibility in the collective and class action areas. Again, attorney's fees we've spoken about on a couple of occasions here, so I won't dwell on this, but it's just a reminder that prevailing plaintiffs are awarded their attorney's fees. It's not the prevailing party, like some of the other discrimination statutes that you might be familiar with. If you successfully defend a claim, you're not going to get your attorney's fees paid back. You might get some costs and disbursements, but you're not going to get your fees. That'll also apply in the record-keeping obligations violations as well. Overtime exemptions. This becomes very tricky to administer on a day-to-day basis. So what we usually advise our clients to do is get all the facts you can and then contact us to help assist you in determining whether or not specific individuals are properly classified as exempt. So the FLSA provides an exemption from both minimum wage and overtime pay for employees employed as a bona fide executive, administrative, professional, and outside sales, as well as certain computer employees. The first test or prompt they must meet is the salary basis test. They must receive a salary of not less than $450 per week. Job titles do not determine your exempt status. You can't qualify someone and say, okay, you're an executive. I'm going to call you an executive, therefore you're exempt. That will not work. In order for the exemption to apply, an employee's specific job duties and salaries must meet all the requirements of the department's regulations. I note here at the bottom of the third bullet, pay attention to Department of Labor regulations changing salary requirements. As many of you may be aware, at the end of last year in November, on our end, we were inundated with calls and requests for assistance related to new regulations that were going into effect. The Obama administration had basically doubled the salary requirements, and employers were finding it impossible to pay these individuals the doubled amount, $913 per week, and still maintain their margins, the profit margins, as well as costs and overhead. So a lot of litigation came up about it, and luckily for employers, a Texas court issued a stay and an injunction preventing that order to go into effect. So that's not currently in effect. However, the Trump administration is discussing and strongly considering increasing the amounts of salary requirements and the overall pay requirements related to overtime and minimum wage. However, that's not been implemented yet, but we do expect an increase to come soon. Some of the specific exemptions to pay attention to that would be applicable to the ASCs and other healthcare industry, the professional exemption. And without reading verbatim here what's on the slideshow, this is probably the most common one that you might be familiar with. The employee's primary duties, the performance of work requiring advanced knowledge. What are we talking about? Advanced knowledge must be in the field of science and learning. These are your typical professionals that people think of. The doctors. You don't have to pay your doctors overtime, of course. If they have a medical degree and they're trained in science and learning, that would make them exempt. Attorneys. In our office, I do not get overtime because of my degree and training. The specific individuals that might fall under this related to the healthcare field are registered nurses. Registered nurses paid on a salary basis may qualify for the exemption. However, we notice in most of our ASCs, hospitals, practices, that nurses are paid on an hourly basis. That's either just an employer's decision, determination, or some of the nurses are part of unions. And pursuant to a collective bargaining agreement, the nurses will be paid hourly at a set rate. If you're paying your nurses hourly and their hours are clocked and checked and that's how you're paying them, they are not exempt. Also, licensed practical nurses are not exempt. They would not qualify even if they were paid on a salary basis. That would be a violation of the FLSA as well as the state laws. If you have a question on that, please feel free to let us know. We can look into that again. One of the defenses in those lawsuits that we were defending were that the nurses were exempt. However, that became a factual inquiry, and because of many of the unions that were out there and the collective bargaining agreements, that exemption was lost by the employers, and the individuals had to be paid on a hourly basis and were entitled to overtime. The administrative exemption, quickly here, we have a few points, but on the second bullet point, we see the employee's primary duty includes exercise of discretion and independent judgment with respect to matters of significance. This is for your office managers, people running your office that will be in charge. They have to set schedules. They can maybe bind the corporation on certain purchasing. That's what you'll look to for the administrative exemption. Executive exemption. Primary duty must be managing the enterprise or managing a customarily recognized department. Employee must customarily and regularly direct the work of at least 2 or more other full-time employees. We're really talking about our supervisors here, people who are in higher up positions. Again, this is a case-by-case basis. Some factors we look to determine if an individual is an executive who's exempt. Can they hire and fire some employees? Do they make decisions based on raises, bonuses, and year-end reviews, promotions, etc. There's also a computer employee exemption. I'm not going to spend a lot of time going through the details of this because I see we're running short on time, but it's good to be familiar with this. What I will note that is your typical IT staff who is performing help desk type information. My Word document froze. Can you unlock it? I'm not getting emails from a particular individual. My phone's not working. All of those type of day-to-day exercises do not make a computer employee exempt under the Fair Labor Standards Act or your relevant state laws. This exemption really applies to someone you might have on staff who is responsible for your software, your systems, analysis of those systems, how to implement them, and how to make them work smoothly as a whole for your organization. We also have highly compensated employee exemption. Similar to some of the other tests we talked about with respect to them customarily and regularly performing at least one duty of an executive, administrative, or professional employee. The kicker here is their salary must be $100,000 or more. So again, that's just one element of the administrative, professional, executive. You don't have to meet all the qualifications if you're paid $100,000. So drilling down here to ASC staffing considerations for overtime, nurses were paid at hourly rates, weekly hours worked, your lunch breaks, pre and post shift work. Those are all considerations that might put an individual over the 40-hour threshold and require time and a half, your overtime pay. Your front office staff, receptionists, sales, marketing, the people doing the intakes, Where we see the biggest problem or claim related to overtime is staff saying, well, I had to meet a deadline, I had to get the billing out. I came in early to do that. I came in late. Or the employer, my boss, told me I have to come in, my shift starts at 9, but we have a weekly meeting that starts at 8, and I have to come in for that meeting 8 to 9. And the employer incorrectly thinks, well, that's not work, that's just a meeting that we have, a staff meeting to discuss things. That's going to be considered part of your time worked if you're there and it's regarding learning for your job. So that extra hour has to be factored in. And again, if they're set at a schedule that gives them 40 hours a week, but now you brought in that employee at 8 a.m. on a Friday for a training exercise, they've now worked 41 hours. If you did not pay that hour of overtime, you're going to be responsible for the hour at the overtime rate, time and a half, the liquidated damages that are associated with that, which is doubling that unpaid time, and the attorney's fees, as well as if your wage statement then says we paid you 40 hours, not the 41, you've now violated the individual record-keeping obligations related to wage statements, and you're going to pay a fine for that instance, as well as attorney's fees. So what we want to do here is you want to make sure there are systems in place that allow employees to submit overtime claims. For example, if you have a predetermined schedule for people, for individuals, your nurses, for example, but they cover a second shift, or they come in early or stay late or work through lunch, there should be some mechanism in place so that that individual can go to a supervisor, an office manager, and say, excuse me, I worked through lunch. Please make sure that's recorded. Or your payroll department that captures that. What we talk about is a checks and balances system. Policy considerations to limit exposure. Employers may have policies restricting overtime or requiring pre-approval, but you cannot deny overtime pay if an employee actually works the additional hours, even in violation of a policy. One thing we get as a question too many times, for my liking, from individuals, employers, is, well, in order to prevent people abusing the overtime system, we have an individual who comes in, and he comes in at 8 o'clock and sits in the cafeteria from 8 to 9, doesn't start till 9, but he likes to punch in at 8. Can we set up a system that prevents anybody from punching in or clocking in until 9 o'clock, the time they're required to work? Well, you might be able to set up your punch clock or payroll clock that way, but if someone comes in at 8 or 8:30 and actually works, but is prevented from logging in until 9 o'clock, you've now just created a bigger problem, a bigger issue, because not only is there a claim for that individual, but now because your policy restricts anyone from clocking in until their start time, you've now opened yourself up to collective or class action liability because you have a policy and procedure in place that affects everyone. And that would cross over from the janitorial staff to the nurses, to the front desk, to everyone if that kind of position is in place. Another task or policy consideration for many employers, and we certainly urge this given the context of some increased litigation recently, arbitration provisions or agreements. While you cannot contract away overtime, what you can do is you can have a policy in place that requires individuals who are claiming an overtime violation to address that dispute by arbitration, and you can also have the individuals waive collective or class action. That's a very big and strong policy consideration because individual plaintiffs' attorneys do not like to sue on 10 individual claims. They want to bring one lawsuit and sue for 10 or 15 people. I can say we've just successfully defended against 2 claims where individuals brought lawsuits in Brooklyn against a healthcare provider, smaller practices, and they claimed they had overtime violations. I don't think the violations had much merit, but we didn't even have to get to that because there was an arbitration provision. We wrote a letter to the judge requesting dismissal, and the other side recognized it, and the cases were dismissed, and they were not able to get the class action. Now, I'll knock wood on this end because they have not refiled on behalf of the individuals. Why? Because they're not going to get, the plaintiff's attorneys will not get the type of recovery or return for their investment that they would from a collective or class action. So that's one of the best policy considerations for employers now. Again, record-keeping measures, have your records so that we can help you defend it so that you have a way to defend against potential claims. Lastly, I don't think I have it listed on here, but I see a question related to it, in a sense of, well, no matter what we do, and I'm paraphrasing a bit here, no matter what we do, it seems as if we are still getting, or we still could get sued for an overtime violation. What do you suggest? Again, that goes back to record keeping, staying on top of your policies, but also audits. We're seeing more and more facilities, employers, companies engaging in self-auditing. What that is they'll contact an attorney firm. They'll contact us. We'll go in and do an audit of the facility. We work with a number of accounting institutions that facilitate that, and that's one way that you can have a history to back up your presentation. So that concludes the slides that we have here.
This is Andrew. So before we go to the question and answer, I want to make sure we have some questions coming in, but I want to make sure that people put it at the bottom of their slides. Also, last plug, please feel free to go today and register for the ASC seminar. So I want to ask you a question before we take the questions from the audience. The personal liability. If I own an ASC, but I had nothing to do with the overtime, I was a doctor, I own the ASC, I did what I did, could I have to pay money out of my own pocket?
There's some potential for there. If you did not specifically manage and control and supervise and set the hours and the schedules, no, you'll likely get off the hook at the end of the day. However, you will be named in the lawsuit more likely than not as a way to get your name out there,
right,
and as a way for the threat of plaintiffs, if they can figure out who the owner is, to say to you, we're coming after you individually. It's somewhat of a fear tactic, but we do see, for example, in those hospital litigations that we mentioned, the CEOs of the hospitals were all named, and all the top individuals on the board of directors were named as individuals. Mm-hmm. And we made motions to get them out, and for the most case we were successful, but in some cases the court said, well, we think they should get out. They ultimately might not have liability, but it's too soon to tell now. Wait months.
And also with ASCs, you can always find out who the owner is. It's owners,
public, right?
And most of the owners are on the board, so they're going to be hard saying that they're not in some kind of responsibility. Okay, so that's a scary thing. Next question. If you find out that a vendor made a mistake, they were doing that 50 hours, just rounding off, can you go after the vendor to say, hey, you better step in here and pay for all the problems?
No, there's not going to be liability associated with the vendor, because as the employer, you are primarily responsible for your policies. And typically, what happens is that the payroll vendors will tell you they're just there as input, export. They're going to import the information you give them and put it out. They're not your attorney. They're not responsible for your payroll policies and making sure they have the right information. So they will not be responsible.
Okay. All right. So let's go to some of, we're going to make this bigger. We'll go to some of the questions that are coming in. Hang on, just like technical difficulty. Maybe we can just pull it over here. Okay. Is there a minimum hour we need to pay for if, say, an employee leaves within an hour?
There's certain rounding regulations, but if the employee starts the hour, they would be responsible for payment of the hour. The rounding provisions apply really towards more showing up and leaving, so you have a 7-minute window for when someone arrives or leaves. That would fall back to the original hour worked. So if you start at 9 but you get there at 8:55, you're not going to be responsible for that 5 minutes. The clock can start at 9 o'clock. Some of the other provisions which we can get into or we can respond to more individually relate to call-in pay. For example, if someone's called in for a shift and then sent home, they are required to be paid for that shift.
Okay. Next question.
One I have here that's actually very good is, can I require mandatory overtime of my staff? Actually, for nurses in particular, the answer is no. New York recently, within the last, I think it's 10 or so years, passed a statute that, a law that prevents and bars mandatory overtime. If you think about it, it makes sense with respect to the nurses in particular, because the nurses were finding were having problems or sleep deprived or working too many shifts. So with respect to nurses, at least, there is a bar against that in state law, New York, New Jersey, and Connecticut. The federal law, however, does not have such a bar, and there would not be a bar for your other individuals, your office staff, your laborers, etc.
Okay. Another question. If you get the call from the attorney, can you, is it a waste of time to say, hey, can we just get in a room and work this out? Or is there an economic incentive for the attorney not to want a quick recovery?
And that's a great question, Andrew. And if a lot of attorneys now we're seeing are doing is they're sending draft complaints. And what that is a sign of is they want to resolve the case in a room behind closed doors, one-on-one, before it becomes a full-blown litigation. The reason for that is courts are scrutinizing what settlements are being reached. So it's time-consuming, and a lot of times the attorneys, quite honestly, the plaintiff's attorneys will want to just settle outside of a court just to get the money for the individual and for themselves and move on. It's also why many individuals are going to state court as opposed to federal court with these lawsuits. State judges tend to be less hands-on and award greater attorney's fees.
Okay. So I think we're nearing the end of our hour. I see another question.
There's one last one just touch on quickly. And we do get this question quite a bit. Can I limit overtime or the rate of overtime with an agreement? As I mentioned earlier, no, you can certainly not contract around overtime. Sometimes we see different agreements, hourly schedules, weekly schedules with individuals. You cannot contract around overtime. That's something that's been litigated and been enforced. So you can't say to an hourly employee, we're not going to pay you overtime because we're going to pay you some additional rate or schedule. Again, with respect to the rate of overtime, there are those very, very limited exceptions upon which you can come up with a rate, but it has to be agreed upon. It has to be in writing, and it has to be because of specific circumstances. A regular employee working in a normal capacity, one set designated description, working more than 40 hours is entitled to overtime at time and a half that hourly rate.
And can you get insurance for these kinds of things?
You absolutely can. There is EPLI insurance. Most people don't have them, but more and more employers are having insurance put in place to cover these type of claims, and they will be defended and provided by insurance defense coverage.
And do you know if most businesses have that kind of insurance?
We're seeing most do not. We are seeing some of our larger institutional clients do have it. However, I will say that it looks like those policies are newer. So they're add-on policies, or there's something that's been developed more recently where you might be dealing with the normal insurance carrier on the employment discrimination claims, Chartis, FOJP, we see a lot. Now there's a different carrier involved that you have to go through specific to the wage and hour litigations.
Okay, so I'm going to limit you to 2 takeaways. If the people listening here are going back to their organizations, what should they do today?
They might want to consider an internal audit, just going through the individuals they have on staff and seeing, are we classifying individuals correctly? And from secondarily, what are our payroll policies like? Do we have a clock in, clock out system? Or are we a little more old-fashioned where we have a piece of paper where people write things on? What systems do we have in place that we can turn to say we pay for overtime?
Okay, and of course that would mean call our great firm, Garfunkel.
Absolutely.
So thank you, everybody. Go register, and really appreciate the time that Sal took, and thank you very much to everyone for participating. Thanks.
Thank you guys very much. Look forward to hearing back.